Hey, everybody, welcome to another great LinkedIn Live episode. We are here live as we always are every month, and I'm here with Advize Health's General Counsel, Julie Janeway. I am Eric Rubenstein, Senior Director of Litigation, Fraud, Waste, Abuse here. And we are super excited because we've got Julie here as our General Counsel. She's been here now for a few months. And we thought it'd be a good idea to talk a little bit about compliance. Julie is a healthcare lawyer. Has been in the space for about 25 years, does a lot of work in the civil and regulatory space. She's not a criminal defense lawyer, but has worked kind of on the periphery of things that have those parallel proceedings. So we thought this would be a great opportunity to talk about all things compliance related, and really compliance as a culture is where we want to
Yeah.
ultimately go. But Julie, welcome to your first LinkedIn Live here with us here at Advise. And just give everybody kind of that thumbnail bio of who you are and how you got here.
Well, I am and thanks for having me on. I appreciate it. Hi out there, everybody in TV land. Um, I have been an attorney, as he says, for 26 years now. I was a paralegal before that, so shout out to all the paralegals that are out there. I'm also a law professor, and I've been teaching graduate, doctorate, and law school health law and multiple related courses, business organizations, employment, compliance, obviously, risk management. I've been doing that for about 30 years. Um, and I'm what they call a deep field health lawyer, broad spectrum. So that means I don't specialize in something like just mergers and acquisitions or something like that. I have a very, very, very broad background. And I have been representing clients. I have been consulting with hospital systems and academic medical centers, working with vendors, working in the pharmaceutical space, in the pharmacy space, FDA law, and a whole pile of other things. Lots and lots and lots of federal law, but a ton of compliance because every one of those areas is, major league compliance based. So that's kind of the thumbnail, and I'm, just yeah, I do a lot of things. I've worked in a lot of fields. So
Yeah, and and one of the things that that Julie, that you're going to be helping us with is expanding our offerings as an independent review organization to help with putting together some more robust compliance plans and things of that sort. And so the first thing I want to talk about from a compliance perspective is it's not an option, right? I mean, it's a mandatory thing. Providers need to do it. And while it is codified in the Affordable Care Act of 2010, but there really is a history of compliance that goes before that, right? So let's talk a little bit about that.
yeah, that's absolutely true. And so, we used to have we still have corporate integrity agreements, but that's all we had. So it was very reactive, right? So everything happened once there was a problem that was discovered, whether a fraud, waste, abuse problem that was discovered. And then it was, okay, well, how do we fix this? And you didn't get a lot of good options, right? You got a corporate integrity agreement if they thought you could be rehabilitated. And if you didn't, you got, prosecution and generally federal jail time on top of it. So ultimately, when the PPACA, the ACA, as most people know it, the Affordable Care Act, when it was being negotiated over numerous years, and of course it came in 2010, they said, look, let's get proactive on this and let's make people have to do this. And we're just going to, put the thumb on their heads and say, get your act together. So it was codified in the ACA. And the ACA also modified the Social Security Act, which governs Medicare and all the federal healthcare programs. So the Social Security Act, both of these acts, major federal acts, have made it mandatory. And it's mandatory for everyone in healthcare. Okay. And just to be clear, because I know when I say everyone, people think hospitals, all the hospitals. That's what she means. No, that is not what I mean. So what I mean is that listen up in case you hear the practice or the entity you belong to. Okay. So you know what I'm saying. So physician practices for sure, skilled nursing facilities or SNFs, rehab facilities, long-term care, home health care, hospice, clinical laboratories, third-party medical billing practices. Nobody thinks about that one. Okay. ACOs, accountable care organizations, children's special health care services, adult primary care facilities, chiropractors, pharmacy and pharmaceutical manufacturers, dental practices, ambulance providers and suppliers. optometry practices, physical and occupational therapy, mental health entities, research, urgent care facilities, nutrition counseling entities, managed care organizations, Medicare Advantage organizations, prescription Part D plan entities, prosthetics and orthotics, durable medical equipment. And then there's your downstream entities, because anybody that you contract with, you have to have that compliance program. You have to make them aware of it. They need to follow it. And you're responsible for making sure that they follow it, and you can't contract that away. So when we say it's mandatory, it's ubiquitous in healthcare. And Eric and I are doing this because we are daily amazed, daily, just befuddled at how many entities in healthcare do not know this and do not have one. And we're on kind of let's save our friends and family out there in healthcare, you know, all of the companies that are out there doing great work. Let's save them from the disaster that can come from not having this. And it isn't just your compliance, it's how it can affect and how it can be affected by a million other things.
Right. You know, so what's amazing to me is that it ultimately what it comes down to is that if you do anything that either builds a program or causes a program to be billed, you're going to be covered by this. And I think the piece that people tend to forget is this cause, right? Because you don't have to directly submit a claim to the program, but if you are facilitating that claim to be submitted. Like, for example,
exactly.
You know, in the device world, like one of the biggest areas of fraud that we know of are in the device industry, is, you know, these companies, manufacturing companies, you know, they come out with a product and they give a suggested billing guide. Well, they're not billing the program directly, but what they're doing is they're providing information that is causing a claim to be submitted. And if you're giving bad information out, well, guess what? You can get wrapped up into any fraud, waste, abuse, criminal, civil, or administrative piece of the puzzle. So, you know, that's an important piece. The third-party billing one is the one I think that a lot of people in our industry don't really think about or consider as much, because as a third-party biller, you really are, and I say this about people that are coders all the time and work in coding and third-party billing, is you are the first line of defense against fraud, waste, or abuse. And it is important, particularly, you know, in this world where providers are moving their billing operations to third parties, to have that. And one of our biggest concerns is when we hear about billing and coding and auditing companies that are overseas, and the provider is using an overseas company to take responsibility for its auditing, its billing, and its coding. You know, the first thing that I think about is, well, if you're under an audit from a payer and you're trying to appeal those audits, who do you get to step up to you, to, you know, to your defense? If it's someone who's overseas, you can't do that. I mean, there's no one, if you're going to take this to the mat and ultimately go to a hearing or an ALJ or something along those lines, who are you getting to be that appropriate representative to stand up and speak for you? So it is important. Like these are not optional. You know, you've got to have it.
Like, how do you get that person? Subpoenaing people from, you know, some country that is 8,000 miles away. How do you get those people to even come and defend you? You know?
Yeah, I mean, there's just no way, right? But so, you know, so let's talk about, you know, at the very onset, providers, when they become Medicare providers, they sign what's known as the 855 form, right? There's a bunch of different versions of it, and there are a number of attestations that accompany that form. One of the, you know, basics is that you're not going to submit claims that are false or fraudulent. You're not going to take money that's tainted by a kickback, and that you're going to submit claims that are accurate and correct, and that you're going to abide by all of the rules and regulations and policies that are out there. And we just talked about the fact that the Affordable Care Act, when codified, was placed into federal statute. It is a law. It is the law of the land. Now, you know, are the compliance police, the OIG compliance police, going to come and you know, knock on your door? You know, probably not. But you have signed an attestation saying you are doing this and you are abiding by the rules. And so theoretically,
and that you are, at the time you sign it, that you are already in compliance. which you have just told the federal government, I have a compliance program because I took the time to find out what I needed to do. And then it says, and that you attest you will remain in compliance. And so now you're 20 years into it, you still don't have a compliance program.
Well,
and this is the problem, because there are the Affordable Care Act and the Social Security Act say literally have hang on, this is kind of important. I need people to know this. They literally say that you are if you are submitting false or misleading information. So this one is you have certified as true, misleading or false information on the enrollment application. This is an actual regulation, and it says regarding the Medicare or other federal health care program, which also covers, right? It covers CHIP, PACE, CHAMFA, TRICARE, VA, Medicare Advantage, all of the above. Okay, Medicaid
Right.
is also covered under there as well.
Absolutely.
So, you know, if you are participating in any of these, even if you never take a Medicare patient, but you are participating or have the right, you have enrolled, even though you haven't
Right.
billed, you have enrolled, you are lying to the federal government, and they're going to find it when they find something else. And
Well-
if you don't have a compliance program, I guarantee you there's going to be something else that will come up because you aren't preventing it. And then they're going to find it. And then does the ball start rolling?
Right. So, and the key takeaway is that at the end of the day, if someone was going to be charged with that from the onset, there's a federal criminal statute, 18 United States Code 1035, false statements relative to healthcare programs.
Yep.
And so if you submit an application that has false statements on its face, you could be charged with that 1035. So having this compliance program helps to keep you compliant, right? The name implies that. It helps to keep you compliant with the rules and regulations of the program from day one. But now we move forward. Providers now, they have a compliance program, and we talk in very broad strokes about this, but a key piece of this is that compliance plans are living documents. And I know
Yes.
lawyers love to talk about documents as being living documents, contracts, and things that you have to reference.
Constitutions.
Right. Things have to be reviewed on a regular basis, because as the times change and as things develop, the compliance plan needs to be adaptable to what is the current landscape, right? Because rules change and policies change. And I think one of the biggest things that we see are providers creating a compliance plan off of a web-based template that they get for free. I'm a general practitioner, and I'm going to pull a compliance plan from a gastroenterologist or a hospital or a SNF.
Or a financial company on Wall Street that has nothing to do with healthcare.
Right. So,
Yeah.
So these documents, so what is, and I know that this is not, and again, we're talking kind of broad stroke terms. None of this is legal advice. This is just us speaking. But
Right.
generally speaking, how often should a provider review their compliance plan and update it?
Well, I think that you should be looking at it a minimum. I mean, not what I even recommend, but a minimum of once a year. But I think at least every 6 months, because the regulations change all the time. And then laws are changed. And then we have judicial interpretations of law. We have Supreme Court cases that come down that tell us, you can do this, you can't do this, you have to do that, you cannot ever do that. So we have to be looking at things. And this is something that my division here at Advize does. We can go in and we can do those quick reviews for you and let you know, this is out of date. We have to update this. You're missing this entirely. And this is like, a hole big enough to drive a Mack truck through. And you're really at risk. And so, I think that they should be looked at. And then we should look at how you're administrating what you have, whether, what's good and what you already have and what we're going to give you. How are you administrating that every day? And when we say that it's a living document and you're administrating it every day, it doesn't mean it's somebody's full-time job now. We understand Right. Small practices, you've got somebody who's got a full-time job and now they have to be the compliance officer on top of it. Is that a daily 8-hour-a-day job? It is not. But what you have to do is be keeping an eye on it. You have to know what the processes are. You have to know what the protocols are. You have to know, you know, what's going on with your auditing and your monitoring. And I know you're going to want to talk about that, Eric. I know those are your two favorite words. And you have to be making sure that you are watching for the updates that come from the OIG's office, that come from CMS, that say, okay, you know what, this is coming down the pike, or this has now just become become effective. So you have to be getting those fraud alerts. You have to know what to watch for. And I hate to say this, but sometimes you have to kind of give a little bit of an extra eye when you get new employees, because, you know, 99.9% of the time, they're great. But 1% of the time, they're fraudsters who move from one place to the next place,
Right.
taking their little scheme with them.
Right.
And they don't want to stay around and get caught. And this is very true in the pharmacy space. I'll tell you that, like nothing you've ever seen. But yeah, look at it. And it needs to be looked at, you know, you should have a lawyer or a very good compliance specialist, which both of which we have here, but you know, they're all over the country, and you need to have somebody who knows what they're talking about and stays up on this stuff.
Right. And I mean, and that goes.
So short answer, yes.
Yeah, but you know, but that kind of goes to the premise of the point that one size doesn't fit all, right?
Oh.
You know, a practice that has, you know, maybe one nurse practitioner, one physician, you know, their compliance plan may look very different from a multi-specialty practice where there's different lines of business and things of that sort. And so, you know, the fact that these aren't one size fits all, I think a lot of times the problem that comes about is that providers, you know, I once had a project where the provider said, well, we didn't budget for fraud, waste, abuse, and compliance. And I would jokingly
and you said, please
say,
never say that out loud again, and don't put it in
yeah,
writing.
and I, you know, and I said, you know, it's not a matter of whether you're engaged in fraud, waste, abuse, compliance, but you know, really the only people that budget for fraud, waste, abuse, and compliance are people that are committing the fraud. Like they already know, you know, they have their lawyer on, you know, John Gotti, you know, he he had his lawyer on retainer for,
Yes, he
you know,
did.
for that kind of stuff.
I knew his lawyer.
Yeah, so I think, you know, the issue becomes, to a large extent, it's like, while I readily can respect the fact that a provider doesn't necessarily budget for fraud, waste, abuse, and compliance, but they should be rolling into their budget costs to have a compliance plan created, a yearly review of that compliance plan. And if you think about it, it's really like an insurance policy at a, you know, kind of a different line of business, right? It's not a, in case of emergency, break glass. It's an ongoing process, because one of the biggest things that
it's putting sprinkler systems in is what it is.
Yeah,
instead of, you know, break glass and try and get the extinguisher
right,
out.
you're
It's like,
right.
you know,
You're trying to tamp down
Yeah.
things before they become too much of a problem. And you
Yeah.
know, one of the right, so I talk about it a lot on our podcasts. I blog about it. We speak a lot about it. Is the OIG has a bunch of tools out there. They have a website with a web page for toolkits, and it kind of goes through the gambit of kind of some basics. You should never rely on the OIG's information just in
Right.
totality, because it's only giving you,
it's basic. It's
because it's
basic.
basic,
It's minimal
but
compliance
right.
information.
And so, you know, one of the things people seem to understand pretty well is the OIG's model compliance guidance. There's 7 points to it. You know, there's going to be nuances. You're going to add, you're going to subtract, you're going to move things along. And so not all of the 7 points of the model compliance guidance are going to be applicable, right? If you're a single practice provider and you maybe have a nurse practitioner, do you need a compliance committee? Probably not, but you should have a compliance officer, and you should have some of the things. So there are some pieces of that that are offshoots or similarly situated to those.
Let me, this is my, one of my big things. Okay. So let me just get up on my soapbox here for a second. Okay. So there are these 7 basic elements that really do need to be there. And he's right, that you have to make them fit. There is no, like, let me just download a, you know, a compliance program from somebody and change the name. That does not work. That is not going to even be you might as well just have nothing at that point, because it's useless. So here's the point of all of this. It needs to be about you. Okay, it's like writing a biography. You can't write a biography about someone else. It has to be about your practice and the risks that your practice has specifically. I'll give you some quick examples. So children, if you see children, that's a risk. And it's a risk for identity theft. It's a risk for fraud. It's a risk for overbilling because nobody wants to, we can pass it off as, well, it's a child. We have to go the extra mile. There's all kinds of things that are out there that are risks that are particular. So if you have scanning facilities, you have x-rays, you have a CT scanner at your facility, and I'm not talking a hospital, I'm talking like an orthopedic office, right? There are extra, potential problems there. And so you want to address the risks. Now, when I do these, all 7 requirements are in everything that I do, but I always have 2 that I consider are also mandatory. One is HIPAA and high-tech compliance and 21st Century CARES Act compliance. Those are absolutely mandatory because there's a whole pile of other problems and money that can, penalties that can come out of that, including criminal. People don't know. There is a criminal aspect to HIPAA, and not a criminal aspect to HIPAA, criminal aspect to HIPAA violations in certain circumstances. So I always add HIPAA and high-tech violations in because they can cost you so much money, including with breaches and everything else.
Right.
I also put in investigation. So investigation is not really one of the 7, but you also need to know what to do if the government comes knocking. Okay, they're very specific things. So my plans are always more comprehensive. They give you very step-by-step guidance on how to handle things. But let me tell you what a compliance plan is not. Okay, I teach this and I teach law students, and I've taught thousands of law students how to do this and go out and work in healthcare and do this particular thing, writing compliance plans and being compliance officers. But here's what it isn't. It is not an employment manual. It is not written to tell the employees what to do. If you say, you know what, the ethical guidance and our standards of conduct are that you call in to your supervisor 4 hours before you're going to not come to work. That goes in an employment manual. If you're talking to an employee, that's where it goes. That is not what a compliance plan is about. Our compliance program is about. It is not your HIPAA manual. Your HIPAA manual is your HIPAA manual. We can incorporate it by reference to it, but it doesn't have to be reproduced there. And I'll tell you something that it is, though, and that is that it is a statement of compliance. And here's one of the really important things about it. If something ever happened, God forbid, okay, something ever happens, and you are in front of a judge or a jury, an administrative law judge, a hearing officer, wherever you are, what you want is you want to produce this program and you want to say, this is our good faith effort to comply with everything. We may have missed something. We may have messed up. We may have tripped and faltered, but here it is. And here are these, right in the beginning of it, are these strong statements of our intent to comply. And let me tell you, it's also a statement of good, like being a good social corporate citizen, but when you stand up there and the attorney reads from that document to a jury, to a judge, to whoever it is, whatever fact finder it is, and it says, so-and-so practice, complies with so-and-so, we understand our compliance responsibilities. We do this, and well, it shouldn't use we, but the name of the practice complies. Right. We comply. We do not hire excluded individuals. We do not double bill. We do, and it's these very declarative statements. It has huge defense impact, right. Huge. And it's literally exhibit 1 that we use. So it has a lot of things, but let me tell you, if they find anything, if the federal government or the state government, not just limited to the feds, if the state governments find it, because there are almost always companion state statutes, and they find anything they want to come and talk to you about, anything, HIPAA, high tech, how did your breach happen? Who took off with 4 patient cases? Every time such and such, somebody's on from 2 to 4 doing the coding, all of a sudden weird podiatry codes start showing up in your cardiology practice, whatever it is. As soon as they come and talk to you, phone, live is always a problem, but nonetheless, phone, live, over email, whatever it is, they have the right to ask you about your compliance program. And when you say, I don't have one, or what is that? God forbid, don't say, what is that? But
Right.
when you don't have one, guess what? Everything is away to the races at that point, because it's presumed by the investigators that, you know what? Yeah, there's where there's one problem, where there's smoke,
Right.
there's fire.
Well,
Okay.
so a couple of things. I mean, well, number one, the lack of a compliance plan could be construed by a prosecutor as an intent thing, right? You
Exactly.
know you're supposed to have it, and when the provider says, "Well, I didn't know I was supposed to have it," and then they pull out your 855 application, which says, "Well, hold on, you attested to the fact that you had one, so you can't say you didn't know that you're supposed to have one. You know you're
That's
supposed to have one, you
exactly
didn't
how it
have it."
happens.
So that could be a piece of intent. I've actually, during my time as an OIG agent, I actually worked on a couple of criminal HIPAA violation cases. And there are criminal ramifications for that. And I will tell you, in today's world, the Office of National Coordinator is heavily involved with things like HIPAA breaches and such, and violations where HIPAA comes in.
And all of our security regulations.
Office of Counsel to the Inspector General is looking to really ramp up. They've got a couple of lawyers that are dedicated to doing things involving transparency and all of that. But so, as we kind of are coming to the end of time, because everybody's got to get back to work on these things. The one thing that becomes a very important piece of any compliance program is this premise of self-auditing, right? It's one of the 7 points, but and I told you this story before we came on live, is this situation where the provider that I was talking to said that they had, we do self-audits. Our compliance plan has self-audits in it, and we just did a self-audit and we had a 0 error rate. And I thought, oh my God, like that's phenomenal. Like, who has a 0 error rate? And I've heard of some, there are some programs out there where you can get your error rate down to, below 1% or 0. And I said, well, how are you achieving that? And the provider said, well, my billing manager audits the billing team. And I thought, well, that's the fox watching the hen house. The billing manager is never going to say that their team stinks.
Yeah.
And so, right. So, you've got to have a cadence. And so when we talk to our providers about putting together proactive self-audits, right? Because you really should be doing them. The question that they always ask me is, well, how many charts should we audit and what's the cadence? And I always say, well, what do you think? I always want to get their opinion. And I've had providers say, well, we'll do 5 charts once a year and then we'll meet compliance. I said, well, the problem with that is, if you've got a problem, it's been going on for a year, but it's a needle in a haystack. So I always refer providers back to the CMS Program Integrity Manual. Chapter 8 specifically talks about sampling and sampling methodologies that are done by CMS or through its contractors, Max and UPICS. And I would say, look, I don't think we necessarily need to do statistical sampling. I think probe sampling will work, or targeted sampling. Sometimes there's something also known as convenience sampling.
It's defensible. These are defensible things.
And the Program Integrity Manual calls probe sampling between 20 and 40 charts. I always split the baby and I say, let's do 30. And I always say we should be doing this at a minimum of twice a year. And depending upon the size of your practice, maybe more.
Quarterly.
Right, or more, because at the end of the day, the issue really becomes, do you want to be in a situation where you want to find your problems soon, and you want to rectify them quicker so that your financial pain is less? If you've waited a year to do a review and you now have $1 million in overpayment, you might have only had 100,000, $250,000, whatever that number is. It'll be clearly less painful if you fix the problem where it is.
And you've missed your self-reporting window. So, that's a big problem, and you lose all the, not that I get a ton of benefits, but you lose the benefits of that, because they're like, you have a requirement to monitor and audit. Monitoring is ongoing. Monitoring is the movie. Auditing is the snapshot. Okay. And you're required to you can't come and say, oh, it's been a year now. And they said, well, you should have self-reported that, Medicare paid you millions of dollars, and you lose all that benefit. You lose all that defensibility. And then they're just going to come after you because you didn't do the absolute normal, reasonable thing that you were required to do.
And you know, and I'm amazed because sometimes, you know, when I talk to lawyers that are in the space and they're putting compliance plans together, they're not really pushing this self-auditing piece by a third party as much as I think they should. Because
Yeah, I agree.
while the OIG is not inordinately clear about who should be doing it, I think, you know, you've got to take the proper approach, which is a third party auditor who has no
Independent.
vested interest. I
Yeah.
mean, in a corporate integrity agreement, and so the OIG kind of collaterally talks about this because in a corporate integrity agreement, there will be language about auditing and
Yeah.
reporting by the IRO. IROs, independent review organizations, and we've done IRO work before. You have to submit as an IRO. We have to submit an attestation that says we will be independent and objective. Well, if the OIG is already kind of collaterally telling you in a CIA what those requirements are for your IRO for self-auditing under the CIA, why should you take anything that is less than that, right? And I think that goes back to this culture of compliance that you've got to get this buy-in. So, you know, we're
compliance saves you money. People think compliance costs you money. Compliance, you know what? You buy an energy efficient appliance to save money, and you will do that. And you might only save $300. You spend, you know, $1,200 for the wash machine. You save $300 in energy costs. Why can't you apply the same thinking, except that you're going to save potentially millions of dollars and jail time and exclusion and everything else?
Right.
It's really what you spend money on med mal insurance like there's no tomorrow, but you won't spend it on compliance. And I don't understand that thinking. Compliance is your friend. It's not the enemy. And you really need to understand what the government can do and the implications that they can, like doing internal investigations of any kind, which includes auditing is if you're doing it internally, we're going to kill you. I was a defense attorney, but they're going to kill you. Prosecutor at USA, U.S. attorney, thank you, I'll get it all out there. They're just going to kill you in 10 seconds flat of questioning, and you're going to just dig a hole and pull the grass in on top of you. So really, this compliance, and this has to be a living program all day, like not all day, every day, but everybody has to know about it. There's training. They'll nail you on not doing your annual training that's required under it. They'll nail you on not doing your onboarding training, which has to be done within 30 days of start. They'll nail you and nail you and nail you. Just do it. It's easy. We do them all the time, and we can customize for you very easily. And mine go way beyond the minimal. So you're going to have a really good protection document. Please.
Yeah, no, it's a true story. And you know, the internal piece, and we're kind of getting to a wrap-up time, but the internal piece becomes an important piece because at the end of the day, one of the things that the Department of Justice now looks for, right? It has compliance guidance that is different. The OIG's compliance guidance is what to do to stay out of trouble. DOJ's compliance guidance is what to do after you've gotten in trouble. But one of the important pieces of the DOJ's model compliance guidance for corporations for corporate accountability is this whole premise of cooperating in the investigation and doing an internal investigation, because the days
parallel of internal investigations,
the days of people who were actually the finger pointing people who were responsible, the days of protecting them are long gone, right? Because corporations shouldn't be doing that, right? Where the corporation was taking the hit, you can't put a company in jail, so they'll plead guilty, so they'll get a DPA, so they'll get a corporate integrity agreement, so they'll get monitoring.
Get a Jai Bungo fine, so what?
Right, but it's the price of doing business. So as we come to kind of this conclusion, we could talk about this for hours, and we do talk about this for hours, but give me some of your final thoughts. What, you know, in the compliance space, where do you see things going? They're not loosening up, that's for sure. But where do you see some of where are the areas of weakness? Where are the areas for improvement that the provider community, regardless of whether they're a direct or a downstream or a third party, where can they find efficiencies in having a more robust compliance?
Training. You've got to have this compliance, this culture of compliance. And that people say that's big. I don't even know what that means. It just means that we all follow the rules. We're ethical. We're not looking for shortcuts, and we all will help each other remember what needs to be remembered. There's a lot of stuff, HIPAA, high tech, coding, billing, 5 million things. And we will all play a part. It's a team sport. Compliance is a team sport, people. And the goal is to keep the ball out of the government's hands. Okay, and play fair. And that's, I mean, just take it back to kindergarten rules. So with that, the other thing is that the government, brings back billions and billions. I think last year it was like $5 billion or something that they got back. And when you get nailed, you don't just get nailed for the amount that you overbilled or that, you fraudulently billed or whatever. It's triple damages plus civil monetary penalties, plus this, plus that, plus the federal sentencing guidelines, if there's a criminal aspect to this. And by the way, it can be civil, criminal, and administrative all at the same time. Do you know what your legal fees are? I mean, really, like, as soon as somebody comes in, a lawyer says, I'm going to go buy a beach house in Malibu. That's what happens there.
Yeah, no,
exclusion
is
horrible.
Point.
Right now, the government is never going to let up, and they're getting more and more and more coordinated. So doesn't matter where it is, one thing, and then all of a sudden it leads to everything else. And we should come back and do one on the exclusion rule so that people understand what's at stake here. With people who have licenses, you need to understand what's potentially at stake. And it's not to scare you, but you have to be informed. But this is a living document, and they're going to ask you, if you come in and you give them a dusty old book from 2011, and nobody's ever seen it, and nobody knows it's there, nobody's been trained, you don't have training materials, blah, blah, blah. I'm telling you, they're away to the races at that point, and you're kind of done.
It can't be it can't be a paperweight. So yeah, I mean, this is to me one of the most important things. And I would say all the time, when I was an OIG agent, outside of the people that were committing criminal fraud, because they don't care about the rules, so it doesn't matter. So this isn't a conversation for them. But I certainly think that there was a percentage of practices and businesses that I dealt with in my civil context on the waste abuse side, where if they actually had an actionable compliance plan and followed it and did what they were supposed to do, that I would have likely not met many of the organizations and people that I met with along the way, because the compliance plan as a living document is meant to be used as that guide. It's the roadmap to follow. And, again, if you're committing fraud, then it really doesn't matter. So look, if you need help out there, call me. We have people that we're very personable, we're very real, we're very helpful, we're very affordable, and I'll help you do this. Okay. I mean, I wrote a national paper on this that's sitting in the Library of Congress. I'm literally a national expert on this subject. So come, we'll do it. We'll do it very efficiently, and let us help you stay in practice and do what you went into healthcare for. That's the point. Right. Yeah, I mean, look, as time has moved on, it's really become from the practice of medicine to the business of medicine, and there's clearly a melding of of those two things together. So, look, Julie, we could talk about this. We do already. We talk about it for hours. We just don't do it. We just don't do it for an audience of people that are caring enough to listen. So, thanks for coming and taking time out of your day. You are the busiest person I know next to Jean Marie Lauria. You are. It's just there's always something going on. So it was great. Thanks everybody for tuning into this month's episode of LinkedIn Live. As always, you can catch our weekly podcast, the OIG Roundtable. It comes deployed in our newsletter. If you are not getting our newsletter, please let us know. Shoot us an email at hello@advize, ADVIZE health.com. Get us on LinkedIn, sign up, become one of our followers. Our newsletters get put out on LinkedIn. The LinkedIn Live recordings after the fact are put up. You can get us on our YouTube channel. Just search for Advize Health on YouTube. You can get all of our prior LinkedIn Lives, as well as all of our prior OIG roundtables and our newsletters and the sort. So thanks again. We really appreciate all of the support, and we'll see you at the next LinkedIn Live next month. Thanks, Julie.
Thanks. Bye.